So hi guys, we'll be starting with the next second watch. Yes. So we'll be starting with the next topic, which is the exception of intoxication. Intoxication, मैंने आपको जो पढ़ के भी जब हम पढ़ रहे थे तो मैंने आपको बताया intoxication is under section 23 and 24 of the Bharatiya Nyaya Sanhita, right? The maxim which you can use here is qui peccat ebrius luat sobrius, right? He who sins when drunk is punished when sober. Beautiful. Right. So section 24 is equals to the limited exception to section 23 in the sense that it provides that where knowledge or intention is a definitional ingredient of a crime, the law will presume only knowledge and not intention on the part of a person, even if he is voluntarily intoxicated. Right. Thus, voluntary drunkenness is no excuse under law. भाई अगर आप खुद परख के जान आसपास देख के पी रहे हो so it is not an excuse under law. However, a close reading of section 86 shows that voluntary intoxication would be defense in cases where a crime requires an intention, but not where mere knowledge would suffice to establish mens rea. Right? You have to remember this thing. Elements क्या क्या हैं section 23 में defense के? So one is incapable of knowing the nature of act committed, incapable of knowing what he was doing, was contrary to the law, was administered an intoxicating substance without his knowledge और अगेंस्ट हिज विल. ठीक है, इस बात का हमें ध्यान रखना है. सबसे पहली बात तो हम सेक्शन 23 और 24 की हेडिंग्स पढ़ लेते हैं. 23 एंड 24. 23 में क्या लिखा है? एक्ट ऑफ अ पर्सन इनकेपेबल ऑफ जजमेंट बाय रीजन ऑफ इंटॉक्सिकेशन कॉज्ड अगेंस्ट हिज विल. 24 में क्या है? ऑफेंस रिक्वायरिंग अ पर्टिकुलर इंटेंट और नॉलेज कमिटेड बाय द वन हु इज इंटॉक्सिकेटेड. रिमेंबर दैट. तो 24 क्या है? 24 exception is it is a limited exception to section 23 in the sense that it provides that where knowledge or intention is a definitional ingredient of a crime, the law will presume only knowledge and not the intention. ठीक है? Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act without his knowledge or against his will. That is the most important parts of this section, right? So that is the scene. टेस्ट क्या है इसमें? टेस्ट क्या कर सकते हैं हम? Whether by reason of involuntary drunkenness the accused was incapable of forming an intention of committing the offense. ठीक है, अक्यूज केपेबल ही नहीं था, इंटेंशन ही नहीं थी ऑफ कमिटिंग द ऑफेंस. ठीक है, इस बात का ध्यान रखना है. ये जो डेफिनेशन है इसमें केसेस लिखना बहुत जरूरी है. केसेस से एक वाइडर पर्सपेक्टिव हमें मिला. ठीक है, डीपीपी वर्सेस बियर्ड का केस है. इसमें प्रिंसिपल्स दिए गए. इंसैनिटी वेदर प्रोड्यूस्ड बाय ड्रंकनेस और अदरवाइज इज अ डिफेंस टू द crime charged. Evidence of drunkenness which renders the accused incapable of forming specific intent essential to constitute the crime should be taken into consideration. That is very important. With other facts in order at the same time as well. ठीक है, ये प्रिंसिपल्स जो थे ना इस केस के, मैं वो बता रहा हूँ आप लोगों को. प्रिंसिपल्स का मैं लिख भी देता हूँ, ठीक है, ताकि आप लोगों को याद रहे. फर्स्ट इज व्हाट? insanity whether produced by drunkenness. Insanity whether produced by what? Drunkenness, right? Or otherwise is a defense to the crime charge, or otherwise is a defense to the crime charged, to crime. Okay. Then evidence of drunkenness which renders the accused incapable of forming specific intent essential to constitute the crime should be taken into consideration. Second is what? Evidence of drunkenness. which proves the incapability. इसका हमें ध्यान रखना है. This was held in what? DPP versus Beard. Third, merely establishing that his mind was affected by drink, so that was more readily he more readily gave way to some violent passion does not rebut the presumption that a man intends the natural consequences in that. ठीक है. थर्ड क्या है? even if even if mind was affected, even then even then we cannot rebut the presumption that a man intends the natural. जब अगर वो ठीक भी होता ना, तब भी क्या पता वो यही कर देता, क्योंकि क्या पता उसके बैक ऑफ द माइंड में इंटेंशन हो. रिबट प्रिजम्पशन, वी कांट रिबट द प्रिजम्पशन कि नेचुरल कॉन्सिक्वेंसेस में भी ये हो रहा था. ठीक है, इस बात का ध्यान रखना. नेक्स्ट, वासुदेव वर्सेस पेप्सी का जो केस था. एट अ wedding, the accused asked a 15-year-old boy to vacate his seat for him. When the boy refused, he shot him point blank. Witnesses testified that even though he was incoherent, he could walk and talk to others. Court applied Section 86, thereby attributing him the same knowledge as he would have been sober. The accused was found guilty of murder. ठीक है, मतलब इसमें जो डिफेंस थी ना, डिफेंस was rejected. Right. Then Satyanarayan versus Andhra Pradesh. A got drunk, started hitting his wife. Then she tried to escape from the house. He dragged her back in by her hair, poured kerosene and set her on fire, and locked the room from outside. कितनी खराब बात करी. Accused cannot be said to be incapable of forming an intention. Section 86 would not apply, as his actions point to a clear intention to murder. यहाँ पे clear intention दिख गई है. While the law will presume knowledge in cases of voluntary intoxication, intention has to be ascertained from the facts of the case. Facts ही ascertain नहीं हो पाई कि intention थी, इसलिए वो रिजेक्ट कर दी गई. देखिए 2022 में 2022 2022 2022 तेलंगाना हाईकोर्ट altered the conviction from 302 from section 302 to 304 since the accused was in involuntary inebriated condition. However, he was not completely exonerated because he was unable to prove that due due to involuntary intoxication he was incapable to prove the nature of the act. ठीक है, देखिए सजा तो चेंज हो गई थी. The punishment was changed. Punishment was changed, but still कोर्ट को प्रूव नहीं कर पाया कि इनवॉलंटरी इंटॉक्सिकेशन थी या नहीं थी. इनवॉलंटरी इंटॉक्सिकेशन थी या नहीं थी. ठीक है, ये अभी भी प्रूव नहीं हो पाया है. देन विल कम टू द नेक्स्ट पार्ट इन द नेक्स्ट लेक्चर. पसंद आया तो थैंक यू सो मच दोस्तों. डोंट फॉरगेट टू लाइक शेयर एंड सब्सक्राइब. हैव अ ग्रेट डे.